May it please the court, Your Honor, John Merchant on behalf of Mr. Roman. Just by way of roadmap, to give you some idea about the allocation of time and what I'm going to be covering. I've been charged with talking to Your Honor about the conflict issue and the appearance of a conflict and what we believe the evidence to show on that issue. Mr. Sadow, Mr. Gillum will be talking more about the forensic misconduct piece of it. Ms. Willis's church speech, statements made to the media, fraud on the court, frankly, and the book that she gave several interviews for. So I won't be discussing any of those issues. So if you like to ask me, certainly I can try to address them, but that's going to be the focus of their presentation. And then towards the end, other folks may have issue-specific type arguments, either in follow-up to mine or the forensic misconduct. But those are the two lanes that we're going to be covering, but I'm going to do the conflict piece of it for you. And on that issue, Your Honor, this is a matter of first impression in Georgia. I can't find a single case that's been published by the Court of Appeals or the Supreme Court that is based on these facts. There are, of course, a number of different appellate court cases that deal with conflict-related issues and, more importantly, appearance of conflict-related issues. And some of those are based in state law. Some of them are based on the ethical rules that govern lawyers. Some of them are based upon the Sixth Amendment right to due process that's implicit in all of what we're doing here today. I want to remind the court that we're here today on this motion to disqualify D.A. Willis and her office because of her judgment, frankly. She is supposed to be disinterested under the Sixth Amendment, and she's anything but that. The fact that these proceedings have taken this long and through the convoluted way we've made it here today explain that. So as I present my arguments, I want the court to understand that this court represents the guardrails for the Sixth Amendment in this context, and Ms. Willis has already been disqualified once. So I would encourage the court to remember what Judge McBurney did in his order disqualifying. The same argument was made in that case as to whether or not there needs to be an actual conflict of interest or whether or not the appearance of a conflict of interest might be sufficient under the facts. I want to make clear to the court that the law in Georgia suggests and is very clear that we can demonstrate an appearance of a conflict of interest, and that is sufficient. There is, I'm going to be candid with the court, there is a Supreme Court decision from 1996, Lamb v. State, and then there are two Court of Appeal decisions after that deal, frankly, in some dicta that suggests that an actual conflict is required. But the Supreme Court of Georgia, since those decisions came down, has made quite clear that the appearance of a conflict standard still applies. And the reason that's important is I think under the Sixth Amendment, which is where we're at, in order to preserve the defendant's rights under that provision and under corollary provisions of Georgia law, you've got to consider the appearance of a conflict. And the reason why the appearance of a conflict is so prescient here is because if this court allows this kind of behavior to go on and allows DAs across the state by its order to engage in these kinds of activities, the entire public confidence in the system will be shot. And the integrity of the system will be undermined. And so with those sort of public policy and constitutional principles, I wanted to turn to the law in Georgia on disqualification. And Your Honor, I'm going to give you the law, and then I'm going to talk about the facts and how they apply to the law at the end. If you want to talk about the facts earlier, jump right in, and I'll be happy to do that. I'm sure Your Honor is very well prepared and probably knows all the law that I'm going to cite to you. But to give the skeleton outline, the original seminal case that deals with conflict of interest from the Georgia Supreme Court is Williams v. State. That's 258 Georgia 305. And there are basically two methods by which you can disqualify a district attorney. One of them is a conflict of interest, and I'll suggest to the court that doesn't mean an actual conflict. That could mean an appearance of conflict as well, and then forensic misconduct. Importantly, in the Williams case, though, in footnote 4, and I think this is important for the court's analysis about the facts and which box it fits into, the court said there was no clear demarcation line between conflict of interest and forensic misconduct, and a given ground for disqualification of the prosecutor might be classifiable as either. And I think that's important because we have facts that fit in both boxes. So if a state stands up and says, well, there's no actual conflict here, Judge, that doesn't mean necessarily that it doesn't apply to the forensic misconduct. Typically, forensic misconduct relates to statements of the prosecutor designed to impugn the character of the defendant before trial and to affect the jury pool, which we have here, which I'm not going to discuss, but the facts that we have here very much relate to that issue, and there's crossover. Importantly, and I think this is important for the court's consideration of what effect the court's ruling may have, if you deny this motion, there's a good chance, if it's reversed, that we would be granted a new trial. So that means we're going to have to do this all over again. In amusement sales versus state, 316 Georgia Appellate 727, that's a case that cites Whitworth, which is physical precedent only. The court said, if the assigned prosecutor has acquired a personal interest or stake in the conviction, the trial court abuses its discretion in denying a motion to disqualify him, and the defendant is entitled to a new trial, even without a showing of prejudice. So that means if we show the court today, and I think we have through the proceedings today and before, that Ms. Willis has developed a very personal interest in this case, and Your Honor denies this motion, we're coming back all over again if the appellate courts say you were wrong.
So what is that personal interest?
So the personal interest can be, there's no definition of that under Georgia law, and it could be a personal financial interest. It could be a personal interest related to bias against a particular defendant, which sort of falls into the forensic misconduct box. But we have here a very personal financial interest that's been laid out in terms of money received by Ms. Willis as a result of the scheme that she set up. But to get to the issue of the personal interest in the context of an appearance, I think that's important. I do want to suggest to the court that there are a number of cases that post-date this actual conflict of interest language that's suggested in some of the cases from the 90s, that you have to pay attention to what this looks like to the public. And I agree with all of the law, and I'm sure the state's going to stand up here and say it can't be a speculative or a conjectural type of personal interest. We don't have that here. We have something very concrete. And as Judge McBurney put it, actual and palpable, not speculative and remote. That's exactly what we have here. We've demonstrated through the testimony of the witnesses, some of whom impeached themselves, that we have a very personal interest. In the seminal United States court case that deals with prosecutorial impropriety is Young v. U.S. That's a 481 U.S. 787 case. In that case, it's the opportunity for conflicts to arise that created at least the appearance of impropriety. And that's the case that requires that the prosecutor be disinterested. Since a scheme injecting a personal interest, financial or otherwise, into the enforcement process may bring irrelevant and impermissible factors into the prosecutorial decision. Now, there are a number of Georgia cases that sort of repeat that theme. Reeves v. State, 231, Georgia Appellate 22, that's a 1998 case, stated a potential conflict of interest existed and the appearance of impropriety existed. Davenport v. State, 157, Georgia Appellate 704, that's a 1981 case. That was decided 7 years before Williams. When there is at least the appearance of impropriety, a defendant is denied fundamental fairness in the state's prosecution of the charges against him or her. There are also rules that govern prosecutors. Lawyers in general are bound to preserve and avoid even the appearance of impropriety. That's Brown v. State, 256, Georgia Appellate 603, 202, 2002. Head v. State. A prosecutor's close personal relationship with the victim in a case may create at least the appearance of a prosecution unfairly based on private interest rather than one properly based on vindication of public interest. ABA Criminal Justice Standards for the Prosecution Function, Standard 3-1.2c. A prosecutor should avoid appearance of impropriety in performing the prosecution function. 3-1.7f. The prosecutor should not permit the prosecutor's professional judgment or obligations to be affected by the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. So the rules that govern her in her own profession say that this is wrong because she's developed a financial interest in this case. And at the very least, created the appearance of unfairness towards these defendants by setting up a relationship, a prosecutorial relationship with her boyfriend that she'd been dating for 2 years, according to the testimony. So before I move, Your Honor, to the specific facts, you asked, what's personal interest, and I think, frankly, as I was trying to figure this out, I think you know it when you see it. It's just like in the concurrence in Jacobellis versus State of Ohio, Supreme Court case from 1964, Justice Stewart, in his concurrent opinion, said, "I know it when I see it," talking about obscenity. I think you know it when you see it. I think there's enough facts in front of you that you know it when you see it. And so I think that governing principle helps enlighten some of the facts here. And also, I think it's not just financial. In McLaughlin v. State, I think the court's very familiar with that case, 295 Georgia 609, 2014. The Supreme Court essentially said that because the acting DA had become a witness in the case and developed a personal interest in the case due to his daughter's relationship with the victim, that he was disqualified. And because he was disqualified, his entire office was disqualified. So turning to the facts of the case, Your Honor, I think I've got, my role is 20 minutes, so I've got about 8 minutes left. So why the relationship, why did we spend so much time on a relationship between these two people? We frankly couldn't care less if they had a personal relationship outside of work. That is not what the issue is here. The issue is that they began this relationship in 2019. They were dating for 2 years, and then she awarded him a contract where public money, either from Fulton County or the state of Georgia, ended up in his pockets. That decision alone was improper. But what's even more improper is that then she and he used that money to go on personal vacations and trips. If Your Honor will remember, Exhibits 9, 11, and 12 dealt with the expenditures by Wade on trips. If you do the math on that, if you look at what he spent, and then you look at the testimony about what was paid back by Willis, because the cash reimbursement theory, I'll talk about in a second, but if you do the math on what he actually paid for it and what they testified she paid back in cash, you still have over $9,200, $9,200 and $9,247 to be exact, is the amount of money they cannot account for in their testimony. And as Your Honor will remember, there was no mention of cash in Mr. Wade's affidavit. When the best and first opportunity to raise that issue would have come up is when the state filed their response in his affidavit. That is nowhere to be found in there. The first time we heard about cash was here in this courtroom. And so I think so she's received a personal financial benefit of over $9,200 in this case that she can't account for, and the state can't account for. And the reason we can't account for it is because they came up with a cash theory. Cash theory only raises.
Before we get into that, let me ask you this. Let's say they couldn't have, let's say the theory wasn't even there that they had paid it back or that there'd been any exchange. Should there first be a consideration of a materiality requirement?
No.
Have you seen that in this jurisdiction? Or, well, it's not in this jurisdiction. Have you seen that in any other jurisdiction?
I haven't seen that, Judge. And if it was $6, that would still be improper.
Would it be improper where it's a per se disqualification if someone, buys their boss a stick of gum? Is that per se disqualifying because there's no materiality requirement? Well, no, I
don't disagree that it may not meet a materiality requirement, but it's a personal benefit. I won't say that giving a pack of gum is just justification for disqualifying a district attorney. I think that's part of the issue, Judge. I think it's a fact-based inquiry by you.
So there's a continuum involved here.
Yeah, but I think the continuum involves you looking at whether or not, in the grand scheme of things, it violates the Constitution, and whether or not there's an appearance of a conflict, and the appearance suggests that she actually received a benefit, and we know that she did. They admitted it. We don't have to speculate about that. They said that she said she got a benefit. and she said she paid back certain amounts. In that regard, Your Honor, I don't know, would $100 be enough? Would $200 be enough? I think you have to look at it globally and consider all of the witnesses, consider all of the facts, consider the credibility of the witnesses, frankly.
Right.
I mean, Your Honor sat here and watched everybody, so I haven't spent a lot of time going into the specific testimony because Your Honor is well aware of it. But you get to evaluate the credibility of the witnesses as a fact finder. And, you know, just
from a legal perspective, though, you're saying we can't just say dollar amount, look no further. There has to be a totality of the circumstances analysis.
I think it's fact specific, Judge. I don't really want you to pin me down on that because there's no law on it. I can't give you a straight answer because I haven't seen anything like that. And I think if we build a materiality requirement into the case law, then you're down a slippery slope then, because then it's going to be the appellate courts are going to be deciding, well, is $50 enough? Is $100 enough? So I think it's not necessarily the amount of the money; it's the fact that she received it, and it's not insignificant. And I don't think your order has to say because she received $9,200, she's disqualified. I think if we go back to the 20,000-foot level, what's the appearance here? Is this fairness to the defendants? Does it appear that she is interested in this prosecution, or does it appear that she's disinterested? She took the stand. You can tell she's not a disinterested person when it comes to this proceeding, but we also argue she's not a disinterested person when it comes to the prosecution as a whole. I'm going to leave for, I'll resist the temptation to defend my wife, who I believe to be an excellent lawyer and a member of the bar for 20 years in good standing. But I will say this, Judge, you don't just evaluate the credibility of the witnesses. You evaluate the credibility of the lawyers. And Mr. Abadi stood up here in open court in front of national news and the national public and called her a liar. I need to address that for 1 minute. There's text messages that are now part of the record, which now are substantive evidence for you to consider, prove everything that she put in that motion, everything that she tried to elicit from Mr. Bradley was absolutely 100% true. And not only was it true, she verified through the witness himself that the motion was accurate before it was filed. So for the state to get up here and impugn her credibility, it's not only improper, it violates Berger versus United States, which is a case that says the state can't just get up here and make any argument it wants. And I encourage the court to call him out on it when he steps up here. We have to have candor towards the tribunal. You cannot lie to the court, cannot lie to the public, cannot lie to the jury. And I think that's what he did. So there's other corroboration of our view that she was in this relationship. I think, frankly, based on Mr. Bradley's testimony, Your Honor can separate the wheat from the chaff when it comes to credibility. But Mr. Bradley had 2 chances to correct information that he suddenly developed amnesia about, and he just didn't do it.
How does the timing of the relationship impact a financial interest?
Because it's part of the scheme she created intentionally in order to give benefits to her boyfriend. So there's a reason why they fought so hard on this, Judge. I mean, there's a reason that every single subpoena was objected to, every single question we asked Mr. Bradley was objected to, the jumping up and down, all of the obfuscation. There's a reason for that. They know that if Your Honor finds that relationship started in 2019, that the appointment of Wade itself was improper, and if that was improper, then he had no business as an average citizen, along with the fact that they didn't have approval from Fulton County to appoint him in the first place. That undermines the indictment. It creates a structural impairment in the indictment because he had no more business being in the grand jury room than I did. So that's what they're worried about. And the reason why it's important for the financial piece, Judge, is it's how the money ended up going back to her. She put her boyfriend in the spot, paid him, and then reaped the benefits from it. That she created the system and then didn't tell anybody about it. She didn't even tell her dad about it. So I think if in the grand scheme of things, if you're looking at the totality of the facts, and I've got to sit down here in about 2 minutes to make room for my co-counsel. If you look at it, everything put together, judges, they did this, they knew it was wrong, they hid it, and even when they were called out on it, they tried to create an excuse for it by saying it happened after the fact. We know now from the testimony, Ms. Yurdy confirmed that Mr. Bradley, his text messages were accurate, not his court testimony, but that fact was accurate. the motion is accurate. And so also, I do want to point out there's no paper trail here for the cash. I know that this was I know she and her father both testified that they kept cash on hand, which, I mean, keeping cash on hand in and of itself is not a problem. When you're a public official and you're required to keep track of gifts that you receive, then you need to keep track of it. But there's no paper trail. There's no deposit history. There's no withdrawal history. There's no receipts. None of that. So even assuming their testimony could be credible, and we don't think that it is, you still don't have enough information to track all that money that she received. And this is just what we know about.
But does the lack of evidence fall on the state? Does the lack of evidence fall on the state? Isn't that where burdens come in?
Yeah, yes, I think they had an obligation to tell Your Honor, hey, this is where the money went. And they certainly had the ability to do that if they could do it. Since they didn't do it, we have to assume they can't. And if they can't, I just want to remind the court of a very important piece of testimony from Ms. Willis that I think goes to credibility of all of the officers of the court who testified. She met with Wade, and they developed, in 10 minutes after talking about the financial piece, I believe, this cash theory that could not be rebutted. We have no ability to do that. They did, and they chose not to do it. So with that, Your Honor, unless Your Honor has more questions for me, I'm going to sit down and turn the podium over to my distinguished colleague, Mr. Sadow.
Good afternoon, Your Honor. I'm going to speak to what I would call a subset of forensic misconduct. And I'm going to assume that all the law that's been provided to you in pleadings as well as emails, you don't need me to tell you what the law is. So I want to just set up how the disqualification and then dismissal of the indictment should take place under the subset of forensic misconduct. Roman's counsel, Ms. Merchant, filed on January 8 her pleading, her motion to dismiss and to disqualify. We were in court that Friday of that week in which I made it known that that is President Trump, may adopt that motion. I wanted to see what was going to happen before I did so. That Sunday, which would be January the 14th, 2024, D.A. Willis took it upon herself to go to a historic black church in Atlanta, having not responded at all to the motion of Ms. Merchant's client, Roman. And she made what we've now called the church speech. And Your Honor has reference to that. You didn't necessarily want evidence on that, but you know what the church speech was. It was videoed. It was clear that Ms. Willis had notes. She was reading from notes that she had prepared. It was a calculated determination by Ms. Willis to prejudice the defendants and their counsel. How so? By making an issue out of the fact that the person that was challenged in the Roman motion was black, without telling the public or the church members or anyone for that matter that the reason that Mr. Wade was being challenged was not because he was black, had nothing to do with race. It had to do with the relationship that had been alleged and later admitted to by Ms. Merchant. Ms. Willis took full opportunity to prejudice the defendants, and then comes along later in a pleading and says it wasn't designed or intended to be at the defendants at all, or the defense counsel, which with all due respect is just nonsense. The purpose of that was to get public sympathy, public empathy for what Ms. Merchant had already alleged in her motion. Now, that was a violation of the professional rules of conduct. It was a violation of 3.8G. There's no question about it. It wasn't in response to anything that was said. It was a public statement, extrajudicial, for the purpose of making a comment upon the defendants.
It would be in response to a motion that was filed.
But it wasn't filed in a response, in a pleading. It was filed in response to a motion. And the motion were allegations made. If Ms. Willis wanted to respond at that point, she could have said the facts of the matter. Instead, she misstated what the situation was, took advantage of the opportunity, an ethical violation, and the ethical violation makes it clear that you must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Can you think of anything more that would heighten public condemnation of the defendants than alleging that defense counsel and the defendants were making their motion based on race and religion? That's as bad as it gets in Fulton County, with all due respect. That's exactly what Ms. Willis wanted done. And remember, the state still had not responded. So then what we get from the state is we get an affidavit filed as part of their response. And that affidavit says specifically, and the affidavit is Mr. Wade, says specifically in paragraphs 26 and 27 that the relationship did not begin until 2022. It acknowledges the relationship and says it didn't begin until 2022. And the pleading that's filed, the state's pleading in response, indicates not exactly that, but it says there was no relationship as of November 1 of 2021, and that's on page 7. So now we know that timing is the issue, because Ms. Merchant made it clear that we alleged and had evidence that indicated the timing was before Mr. Wade was hired, not after. So the state now has filed an affidavit and a pleading that claims post-hiring into 2022. And then Mr. Wade Willis testify to the same thing under oath. Now, Ms. Yerty says it began in 2019. Why would she know? Well, she would know because she was a former friend. I know the state's going to get up here and say you can't believe, essentially what they're going to say is you can't believe any defense witness because they're defense witnesses. And only people that would tell the truth would be Wade and Willis. I suggest to you that that's not accurate. I suggest that the testimony that Mr. Wade gave and Ms. Willis gave, and I'm specifically dealing now with the timing issue, without getting into anything else, that brought forth a true concern about their truthfulness and being what is required of a lawyer in this state, which is candor toward the tribunal. And that's 3.3 of the professional rules. Specifically, small a1, make a false statement of material fact or law to a tribunal. So that's, as I posited to the court, that's the second ethical violation. And then you also have 8.4 of the professional rules. It says it's a violation of the Georgia Rules of Professional Conduct for a lawyer to, and that's A4, engage in a professional conduct involving dishonesty, fraud, deceit, or misrepresentation. Now, do you have to find that Wade and Willis lied? No. What you need to be able to find is that there is a concern, a legitimate concern based on the evidence in this case about their truthfulness, a legitimate concern about the truthfulness, which equates to an appearance of impropriety. Because once you have the appearance of impropriety under forensic misconduct, the law in Georgia is clear, that's enough to disqualify. So why should you find there's a concern with their truthfulness? ERT is the first one. You have that testimony. But then we go to what is the most obvious indication that Willis and Wade were not truthful on the point of timing, and that's Bradley. Defense Exhibit 26 came into evidence. Defense Exhibit 26 comes in and says, and you know I went into this the last hearing. It says, that on January the 5th, 2024, at approximately 9:49 a.m., there's text messages that are exchanged between Ms. Merchant and Mr. Bradley. And the text messages go like, just date, and that's from Ms. Merchant. Ms. Merchant says, do you think it started before she hired him? Bradley, who we now know from Defense Exhibit 39, has been texting with Ms. Merchant for a number of months. This is not the first time. This is months within the communications between the two. Mr. Bradley says, absolutely. Now, absolutely is not a speculative word. That's not speculation. That's a definitive statement. And Bradley then, unprompted, says this. And unprompted is important. It started when she left the DA's office and was a judge in South Fulton. It goes on, Ms. Merchant says, she liked it started when she left the DA's office with the appropriate emoji or whatever one would call it to say it was liked. And then Mr. Bradley said they met at the municipal court CLE conference. Again, unprompted. He's now definitively telling Ms. Merchant when this relationship started. Ms. Merchant says, that's what I figured when he was married. And then Ms. Merchant says, and we're now talking about a couple hours later, she texts and says, upon information and relief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And Mr. Bradley responds, no, municipal court. Thank you. Doesn't say it didn't start then. He doesn't suggest that she's wrong other than magistrate court municipal. Now we have that, and it's in evidence. And what does Bradley do? He knows that he's put himself in a position that if he testifies truthfully on the witness stand, Your Honor is in a position to be able to find, if you choose to, that both Willis and Wade lied. So what does Bradley do? Look, you were an assistant U.S. attorney. You know how this works when you have witnesses in this situation. Mr. Bradley did everything he could possibly do to evade answering questions. No recollection, couldn't remember, it was speculation. Anything he could possibly say that would cause, Your Honor, not to believe that Bradley knew when this relationship started. I suggest they were clear-cut lies, and the truth is in Defense Exhibit 26.
And so if we take that view, that he thoroughly impeached himself, that he did not give truthful conduct, what's left standing? Generally, you would see someone who's impeached, perhaps we have some kind of core that you could point back to and say that's the time he was telling the truth. In these text messages, is it ever definitively shown how he knew this and that he actually did know it, other than just a assertion outright? Absolutely. Usually, if a state has a witness that goes sideways, they've got him locked in. They've sat down with a detective and got a full statement. We don't have that here.
But what you have is a text message, which is a prior statement of Bradley that he did on his own, that was not given to him by someone else. The only thing that the court has just noted is, how do we know he wasn't speculating? Because you don't have to accept the fact that he wasn't speculating. The cases that I provided, I think by email yesterday, the first dealing with that, you can disbelieve that testimony and draw a negative inference. That's the Ferguson case. On Lee, the other case, you can simply take the prior inconsistent statement as substantive evidence. It has the same value. And that's what I'm asking you to do, to take what was the unprompted statement in Defense Exhibit 26 of Bradley and take that on its face value, that is an indication that Bradley in fact knew and had said he did. If you accept that, you have to have concerns about the truthfulness of Willis and Wade on the timing issue.
And I don't know if this is something maybe one of your co-counsel were going to address as well. We heard about kind of the law that applies, how we're outside kind of the orbit of the core of cases we're used to dealing with here, where it deals with side switching or where someone is in the relationship, the client relationship. The proposition you're putting forward now is that if a representative of the state, a lead prosecutor, the district attorney themselves, says something that's untruthful on the record, that is something that immediately has to be proactively policed by the trial court. Is basically what I'm getting at is, where in the law do we find the remedy to an untruthful statement? Generally, we send you down the street to the bar, right?
And that's why I gave you the cases of Registe and Edwards yesterday. While those aren't prosecutorial cases or dealing with prosecutors, they deal with counsel. And in both those cases, the trial judge found ethical violations on the part of defense counsel, or potential ethical violations. Went through the ethical violations and said, based on that, you're disqualified. You cannot be the attorney of record in this case. What's good for the goose is good for the gander. If defense counsel can be kicked off of a case because of ethical violations, I suggest the same thing can happen for prosecutors when the ethical violations deal with truthfulness, candor to the court, extrajudicial statements. Those are the things that this court can rely upon and say, based on those, again, I find an appearance of impropriety.
Where would be the limiting principle? The district attorney signs every indictment assigned to this courtroom.
No.
Does that mean she's off every case?
No, it would be when the...
If I found that she's untruthful, is that what you're kind of suggesting, though?
You don't have to find, again, I'm not saying you have to find she was untruthful or that Wade was untruthful. You don't have to make a finding of fact that they lied. All you have to do is make a finding of fact that you have genuine, legitimate concerns about their credibility, about their truthfulness. And once you find that, then you can apply Registe and Edwards.
Well, but it's the same principle, though. If I have genuine concerns about her truthfulness on a particular occasion, how do those not spill over into every criminal case a district attorney brings?
Well, it's because she testified under oath, and so did Mr. Wade. They didn't have to testify falsely. They could have testified truthfully. They could have indicated that the relationship, the timing was in fact before Mr. Wade was hired. They chose not to. And in that sense, that dishonesty, that constitutes a violation of their ethical responsibilities. This is not signing an indictment. This is not filing a pleading in which both sides have their own positions. This is a requirement that every witness has to tell the truth under oath. And if they don't tell the truth under oath, or there's a significant concern about their credibility, then they're violating their ethical rules. And as anyone will tell you, as Your Honor already knew from when you were a prosecutor, prosecutors are held to a higher standard. They're the ones that are supposed to be seeking justice. They don't have a particular, they're supposed to be disinterested. When you have the lead prosecutor and the DA giving what I suggest to you is untruthful testimony, based on what Yerti has said, based on what Bradley said in his text, based on the whole way it was presented to you. Bradley didn't want to testify. He first came up with his attorney-client privilege thing on that. Then Your Honor was, fortunately, went into that. And then when Bradley knew he had to testify about it, you saw what happened. You can draw the inference, as I've suggested on Bradley, that what he said in the text message, Defense Exhibit 26, is true. The relationship, in fact, started prior to November 1st of 2021. That ERT says that. And now, without getting into any detail, the cell phone records. The cell phone records show that during that period of time from, let's say, April 1 of 2021 to November 30th of 2021, that there was a considerable number, 35 or more occasions where it appeared that, based on the records, that Mr. Wade was down in the area where Ms. Willis was staying in Yerti's apartment. But more important is there are two occasions, and the state has not challenged those. There are two occasions where the records reflect that it appears Mr. Wade spent the night at that apartment. The state may say, we don't accept that. but they didn't challenge it. And even when they brought forth what they brought forth today, supplemental 2 and 3, they didn't challenge it again. So what does that suggest? That's corroborating evidence of what Yerte had said, of what Bradley said in his text message. It's also impeachment evidence as to what Wade and Willis said about how many times.
Is that a significant, in terms of just the times? Didn't Mr. Wade testify that he was there at least 10 times during that time frame? You've now found 35.
Well, minimum of 35.
Okay.
But never overnight. He said he never spent overnight.
Put that to the side, though, just in terms of the fact that he did say he'd been over there, that he'd visited the place, and I would presume he wasn't obviously keeping a very good accounting of it, but that wasn't something that was entirely denied.
If you're asking me, do we win on the point that he said more than 10 or around 10 and we say 35, do we win on that point?
Sure.
No.
Okay.
It's not determined.
The overnight rate might raise some more concerns. Understood.
Yeah, it does. And that's the reason why we highlighted it in the affidavit of Mr. Middlestadt, because that is suggestive that they were not being honest to the court. So then, how much time have I used? Have I?
I'm letting them use the hook. So, suggestive. Again, raising issues. I'm wondering about burden. Is it we're dealing with a preponderance standard?
We are dealing with a preponderance standard, and it's our burden.
Yeah.
No question about that.
So does suggestive get us there?
No, but it is corroborating evidence of evidence that we did put up. And that's what the purpose of the cell phone records. They corroborate what Yerte says. They corroborate what Bradley said in Defense Exhibit 26. And they impeach, to that extent, Wade and Willis's testimony. So if you find by a preponderance of the evidence, so I can finish this up, if you find by a preponderance of the evidence that what I call subset of forensic misconduct, ethical violations, has been shown, and that there is a significant and legitimate concern about the truthfulness of Wade and Willis, they're disqualified. Now, obviously, the factual findings are yours, but the law allows you to do that. You don't have to do it through an actual conflict. That's the other side of the equation. And that's what I've argued, and I think that's what Mr. Gibbons can argue.
Before I let you go, though, this is an interesting classification. You're saying forensic conduct isn't just commenting publicly about the case indicating guilt. You're saying forensic conduct is just anything a district attorney says falls into that box?
No, I'm saying that
improper,
that forensic misconduct as a subset of that would include violations, ethical violations, which impact the ability of the defendants to get a fair trial, as well as impact the court's ability to have faith that the prosecutors, these two prosecutors, are acting in good faith in their own conduct. Same idea dealing with, as I said, defense counsel in the two cases I mentioned. Ethical violations can give rise to disqualification, and I suggest we have that here.
All right. Thank you, Mr. Sato.
Thank you.
Where's the shot clock when you need it?
Right there.
Your Honor, I want to address very directly here. What we have is a systematic, continuous pattern, a calculated plan, evidencing a design to prejudice the defendants in this case, in the minds of the jurors. This is what we have seen. This isn't the problem that the district attorney has. It's not that the district attorney had some sort of brief off-the-cuff statement in an interaction with a reporter like in Williams. That's not what we have here. We have someone who sat down, wrote out her speech, wrote out her plan, who sat down for whether it's 2, 3, or 6 times with the editors of Find Me the Votes and told and got her message out about this case before it was supposed to be tried in this courtroom. And so that is the problem that we have. We have a pattern of forensic misconduct on behalf of Ms. Willis.
So, I mean, we have a pattern of public statements being made. I take it you or your team has dived in and read the book. I know she was asked about specific portions in it. The only case that I can find actually talking about when someone crosses the line on public comments is that Williams case, and it talks about there has to be an implication of saying a particular defendant is guilty, and it even denied it, right? So have you found any case in Georgia where they actually said that a prosecutor had gone too far in their public comments? Does one exist?
Well, number one, thank goodness it doesn't happen often. Sadly, it's already happened here. Now, in Williams, the prosecutor had one response to an inquiry the court found it was improper, but did not have this pattern. Now, it doesn't necessarily mean a comment about the quote guilt or innocence, although that was the pattern in Williams. It's the improper comments by a prosecutor. For example, in Williams, they cite the nature and consequences of forensic misconduct in prosecution of criminal case, a 1955 Columbia Law School article, and how prophetic that was. When Williams cites that case in that law school article, they talk about an awful lot more than simply the comments about specific guilt or references to guilt. What you have here, Your Honor, is a comment, and we can't look at it doesn't apply only if a prosecutor said, I think the defendant is guilty in my mind. No, it's more pernicious than that. What we have here is someone who sat down and drew up a plan for two reasons. And what she did reminds me of what the court in Estes v. Texas talks about, and that is that pretrial can create major problems for a defendant, indeed more harmful than publicity during a trial, for it may set the community opinion as to guilt or innocence. That's what we have here. That's exactly what we have. And the court in Estes talks about the power of the television camera. So what do we have, and what did this prosecutor do? What she chose to do is sort of what was criticized by the Supreme Court in Shepard v. Maxwell. Legal trials are not like elections to be won through the use of meeting halls, the radio, or the newspaper. That's exactly what we have here. What we have is a deflection. What this is all about is more insidious than just making the comments that she's made. It's a deflection. What she chose to do was to say, okay, I have done my best to hide the relationship with Nathan Wade. And Nathan Wade has done his very best by filing false documents in his divorce case to hide his relationship with Miss Willis. Now, and so what did they do? Well, when Miss Merchant filed the motion to disqualify, now the game plan has to change. The game plan I call the deflection begins to take place. The deflection is when the district attorney sat down and wrote out. I'm sure the court has. When you look at that video, it's in evidence of her speech at church. She has written out everything, and she's reading from it. She chooses to deflect. The court asked earlier, wasn't she really responding to the motion that had been filed against her? Would that she had. Because if she had, she would have looked the members of that church in the face and say, there's been an allegation that I had a romantic relationship with Mr. Wade, and ladies and gentlemen of this congregation, it's true. She didn't do that. She chose to deflect and to do two things that are reprehensible for any lawyer, but particularly for a prosecutor. She chose to pull out the race card and the God card. That's what she did, and she wrote it out. She went on to deflect away from the allegations in the Wade motion, and she said, she's saying, why, in her talk, public discussion with God, why are they only attacking one, in reference to Mr. Wade? And then she goes on to say, God, isn't it them playing the race card when they only question one? Now, if she had been truthful with that congregation, truthful with the community, she would have said, I had a relationship with him. Good, bad, forgive me, whatever. That's what she should have said. But she chose to deflect and say, them, the reference to them and the others and they. It's obviously a reference to the motion filed by Ms. Merchant. They choose to go after the black man. And she then goes on, again, deflecting away and deflecting to what I call the third rail in American society, choosing somebody on the other side of being a racist. So-and-so is a racist. They're racist. She was the one playing the race card in a way to try to deflect from her own conduct. She goes on to say in discussions with the Lord, God, is it that some will never see a black man as qualified no matter his achievements? Again, the deflection. What is she saying? The listener is not necessarily in that audience in that church. The listener is at Fulton County. The potential jurors who will come into a courtroom and say whether or not they can fairly judge the evidence or judge the defense in this case. She chose to inject race into the minds of the listeners and virtually everybody in this community, and literally everybody in this country has reviewed and analyzed her speech that she made in a premeditated way. And in bringing in not only the race card, but also in bringing in the religious matter, this is exactly what Hammonds v. State in our Supreme Court talks about, condemning as an inflammatory appeal to the jurors' private religious beliefs. Why would she do that? To deflect. But now, not only is she deflecting, but she is then going forward and, in a way, telling the community, telling the congregation that God is on her side, not on the side of these people. God, she said, and when she's talking, and she's saying, God, pray for their souls. I, meaning God, qualified you. I qualified your imperfect, flawed self. I see you in every hour. Do my work. As though she's telling the folks in her very, very, very implicit way, injecting into the minds of the jurors, God wants me to win this case. God wants me to prosecute this case. And why is he going, and why are these others going after the black man? Well, the answer is very simple. As we said in our brief, we didn't mention Mr. Cross, the white female, or Mr. Floyd, the white male, because there was absolutely no evidence, and is no evidence, of a personal romantic relationship with them in which she obtained these benefits. That's the reason why we did not do that. So she goes forward with her with the deflections. That's exactly what she does when she goes forward. And she talks about a planned interviews time and time again with authors of the book, Find Me the Votes, where she's talking about a case that's going to be tried in this courtroom. It's reprehensible.
So in that specific, instance, setting aside the fact that she was willing to go on the record before a case had even reached the jury, what specific statements from that book do you contend cross the line?
Well, for example, she's saying, she goes on to talk about all the calls that she gets from people calling her racial terms. And all the calls are racist. What she's trying to do, and I think there's a reference in there to MAGA people, whatever. In that, what she's really saying is that those people calling me up and making those claims or those horrible racial slurs to me are really people on their side of the fence. That's what she's doing. And there's no reason, Your Honor, ever for a prosecutor to sit down and go forward with this kind of interview. She did it in Find the Votes. But then what really happened here is this hiding of the relationship. Because in hiding the relationship, they have done such a good job. Mr. Wade filed false documents in his divorce case. When on May the 23rd, May of 2023, talking about, have you ever had sexual relations with a person during the course of the marriage or including the period of separation? He's still married. He doesn't have a divorce decree, but his answer is none. Then he's asked whether or not, on any occasions, he's entertained or been entertained by someone, a woman, a member of the opposite sex, in this case a woman, from the date of the marriage to the present, talking about place and time and all that. What is the answer? None. Why does he do that? He does that because he doesn't want to tell about the relationship that he has with Miss Willis and the benefits that he has gotten and that he gave to her. That's exact. And what these answers are absolutely reprehensible. That a member of the State Bar of Georgia would file these answers that are inaccurate. What does Miss Wade do? Miss Willis do? Miss Willis, on her financial report, on whether or not she has gotten anything of $100 or more in value from a prohibited source. The court asked earlier about what a threshold might be. Well, for the financial report, it's $100. That's it. She doesn't report any of all of the benefits that she received from Mr. Wade. All the trips, all the entertainment, all the 3 nights in the luxury suite in Aruba. All of that. None of that is here. And they say, oh, well, maybe it all balanced out, even though I can't prove it with the cash. Well, that's like saying, did I give the court a Christmas present? Well, maybe I gave the court a Christmas present, and the court gave me one back. If the court has to fill out a form whether you got a Christmas present from anybody, you say, I got one from Mr. Gillen. You don't say, nah, well, I gave him one back, so it really evens out. They're false reports. And because they're false, what they had to do is they had to say, uh-oh, Ms. Merchant has caught us. And so what we're going to do is we're going to get, in our response, we're going to get Mr. Wade to file a false declaration, which he does. His declaration in this case is false. And the evidence showing that that is false as it relates to the timing, and the court asked earlier, why does it matter, if the relationship was before or after November 1, 2021? The answer is they think it's important, and frankly, I do too. Because when she's hiring somebody and she's not telling the people who are going to be paying the tab up to $700,000, hey, I just hired my boyfriend who's taking me on trip to the Caribbean and taking me down to Aruba and taking me to California. Hope you don't mind. No disclosure whatsoever. And the money flows off. But because they got caught, they then commit what I think is an additional component of forensic misconduct, and that is fraud on this court. When they filed that affidavit, and now it's been proven, I think, beyond virtually any doubt that the relationship occurred prior to November 1, 2021, and the benefits that were there, and we don't have to run around. And I love we've got all the records showing from Mr. Wade about the payment for these trips, for the cruises, for the flights, all this stuff. What's the only way is they sat around and met together before they testified and came up with their story. What's the only way that they can save themselves? Pay no attention to the records. Pay no attention to the airlines and to the flights and vacations and the cruises. I paid him back in cash. Show us your receipts. Where did you take cash out of the bank? Ever? Oh, I don't have any. Well, show us the deposits that he had. Well, never. We don't have any. What we have here is a fraud on this court, which has been shown, I think, overwhelmingly by the evidence and overwhelmingly through not only the testimony of Yurdi, the testimony of the emails and the text from Mr. Bradley to Ms. Merchant, as well as all the documents that they had no answer to other than the just trust me, I gave him money, it evaporated, I don't know where it came from, and he doesn't know what he did with it. Just please trust us and believe us because it's our only way out of the trap that they set for themselves. These people, sadly, and I hate to say, I was a former, as the court knows, I was a prosecutor for about 3.5 million years, it seems, in the federal building, and I was an assistant DA beforehand. Prosecutors don't act like this. Lawyers don't act like this. These people, Your Honor, is a systematic misconduct, and they need to go. Thank you.
Your Honor, I'm going to cover a few factual details without overly rehashing what has already been said. During the pendency of this investigation in this case, Mr. Wade and Ms. Willis basically lived Robin Leach's lifestyle of the rich and famous. And they did this riding on the backs of the defendants in this case, funded by the taxpayers of Fulton County and the state of Georgia, with the money that was paid to Mr. Wade through the contract that Ms. Willis got him. That money flow, that is the personal interest that you asked about. She was personally benefiting from the position, from the job, from the scope of the investigation, from the scope of the indictment, and how they conducted it. And we know this, we know from the records that have been submitted before the court that Mr. Wade paid at least $17,095 towards this relationship. That does not even include the various dinners, the day trips that both Wade and Willis admitted to, so that number is likely even higher. We know from the documents that Ms. Willis only paid $1,394 for an airline ticket. We know from Ms. Yurdy, who was pretty much uncontested, there was no evidence presented by the state disputing her time frame, that relationship started in 2019. She saw them kissing, she saw them hugging. Now, whether or not they had sex before January of 2022, I do not know. They admitted sometime in early 2022, and I found it curious that they both, Wade and Willis, just went straight to the sex. So maybe that's when they started having sex. I do not know. But the relationship predated that. And their combined and overly suggestive focus on that is a red herring to this court and to the defense, that that's what they want you to focus on. They want you to ignore all the evidence that the relationship predated that. The relationship started in 2019. The relationship continued through 2020. The relationship continued through 2021. Looking at the cell phone communications, just in the first 11 months of 2021, over 2,000 calls, almost 9,800 texts. You know, I don't even think love-struck teenagers communicate that much. The November 29th and November 30th escapade, phone call from Ms. Willis, between Ms. Willis and Mr. Wade, 11:32 that night. Shortly after midnight, the phone starts traveling down from where Mr. Wade lives and ends up where Ms. Willis is staying, and he's there until roughly 4:55 a.m. None of the excuses, none of the explanations that Mr. Wade gave, go into the Porsche experience, go into dinner, go into the airport, none of that explains that. I'm pretty sure the Porsche experience isn't open in the middle of the night. I'm pretty sure that there weren't any restaurants that he drove 30 to 45 minutes to go eat at in the middle of the night right after he talked to Ms. Willis. Teenagers have a name for those kind of calls and those kind of escapades. I won't go into it. But the documentary evidence, the objective evidence, undercuts everything that both Wade and Willis said. When you look at Ms. Yurdy, again, she unequivocally said that relationship began in 2019. She saw physical evidence of a romantic relationship. Mr. Bradley, in the text messages, which are substantive evidence, said that that relationship began in 2019. Again, his January, temporary amnesia that somehow was triggered temporarily after Gabe Banks called him, we can question that. But we do have statements from him that specifically said that relationship predated Mr. Wade's appointment by Ms. Willis. You asked, well, in Mr. Wade, you asked what the materiality would be. How much is enough? Well, clearly $17,000 is enough. But Fulton County has told us has told Mrs. Willis what the materiality is. It's $100 in a year. She twice signed declarations, certifications that she did not receive any gifts. And even under her strained explanation, there were monies, there were gifts, there were dinners, there were excess contributions flowing her way that exceeded $100. Her explanation, well, I just paid it in cash. That just does not stand to reason. It does not hold up to the light of truth. Anyone that has ever been in a money laundering trial, a forfeiture trial, if that's the explanation we give the state, they laugh. Oh, I just gave cash. I have no records for it. I have no source for it. The only thing that she could say that was a source for the money, because at times she said she was down to $500 to $1,000. The only explanation she have is, well, sometimes I go to Publix and I may get an extra $50. That shows up on your debit card or your credit card. Did they bring those records in? No. Did they bring her bank accounts in? No. Did they bring any documentary evidence in? No, they did not. And why is that important, Judge? Yes, the burden is ours. But under OCGA 24-14-22, if a party has evidence in such party's power and within such party's reach, by which he or she may repel a claim, and they had that power, Ms. Willis had that power, Mr. Wade had that power, that they can repel the claim that we have made against them, but they admit to produce it, or if they produce weaker evidence, then you, as the fact finder, Judge, it is in your power to disregard that, and a presumption arises that that documentary evidence that is in their possession that they failed to produce supports our claim. And that is something that the state relies on regularly in criminal trials. And that is something that the court should rely on in this case when formulating its factual findings. And we know that both Mr. Wade and Ms. Willis have some difficulty expressing the truth when it comes to their relationship in these cases. We know Mr. Wade lied in his interrogatories multiple times. We know Ms. Willis falsely certified that she hadn't received any gifts from anybody. And Mr. Wade clearly was a prohibited source. He was someone doing business with Fulton County. Anything over $100 in a year, she had to put down, and she put zero. And it defies imagination that she could somehow forget about all these trips, all these dinners, all these day trips, and not put that money down. You had asked, I think it was Mr. Gillen, did she say in that church speech or anywhere else that the defendants were guilty? And I think she did in that church speech. She said in that church speech, and she was talking about a conversation that she apparently had with God, talking about herself. She said, this leader has a trial conviction rate of 95%. She said, the trial team this leader put together has a conviction rate of 95%. I do not see how anyone, and I think that was purposefully intended by Ms. Willis, I do not see how anyone can listen to those two statements and not take that Ms. Willis is telling everyone in that church and everyone that's going to hear that in the media afterwards that these defendants are guilty. That is what she was saying. She is a prosecutor. She's familiar with the U.S. v. Berger. Every single attorney that's ever been a prosecutor is familiar with the dictates of that U.S. Supreme Court case. That is a foul blow. That is improper, and she violated pretty much every tenet a prosecutor must abide by to seek truth and justice in a particular case. So, Judge, when you're looking at this, the uncontroverted evidence shows that they had a relationship prior. The uncontroverted evidence shows that Mr. Wade lavishly spent on Ms. Willis. The uncontroverted evidence shows that the money that he was spending on Ms. Willis came from this contract that he had. And I'm not just talking about the contract as a special prosecutor, but there's also those other questionable contracts that no matter whom his partner seemed to be, they also got. There is a direct financial benefit that Ms. Willis received from this. And Judge, looking back at what Judge McBurney said, if merely hosting a fundraiser for a political opponent of a putative defendant creates not only the appearance but an actual conflict, then what Ms. Willis has done since then in this case creates an actual conflict. But again, as prior counsel has stated, we only need to show the appearance of a conflict. And we have done that by a preponderance of the evidence. In fact, I believe we've shown an actual conflict. But nonetheless, the result should be that Ms. Willis and her office should be disqualified from this case.
I'm going to talk further about conflicts, and I'm going to assume the most difficult standard for us to meet, which is actual conflict. But before I begin that, I want to add just a little bit to what has already been said about the standards that apply to prosecutors. Our appellate courts have said often the administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice so far as it is possible for our courts to accomplish it. The first occurrence of that I can find is Nichols v. State more than 100 years ago, 1915. The most recent, Registe v. State in the Supreme Court in 2010, although they don't refer to Caesar's wife. That requirement is also embedded in the prosecutor's statutory oath, 15-18-2, which requires impartially and without fear or favor discharge my duties as district attorney and take only my lawful compensation, so help me God. The general rule on conflicts of interest for lawyers is in Rule of Professional Conduct 1.7. And we all know, it's all drummed into us, that we cannot have a conflict of interest. And if we do, we have to withdraw or we will be disqualified. The basic idea is that a conflict of interest impairs the lawyer's independent professional judgment. That's the test of a conflict and whether it can be waived and whether it's disqualifying. And that conflict is not just financial. It can be any conflict that impairs your independent professional judgment, and you see that in McLaughlin v. Payne. The court asked what was a personal interest for purposes of disqualification. It's anything that impairs professional judgment. That's reflected in the ABA standards that were quoted by Mr. Merchant, which list the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What my colleagues have described as forensic misconduct is also cognizable as a conflict of interest based on that footnote in the Williams case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests in perpetuating and concealing their relationship. That's the original sin from which all of the other problems flow. There are 6 different actual conflicts of interest in this case, any one of which warrants disqualification, but collectively, practically compelling. First, the financial conflict that's already been covered. Second, the personal ambition, political ambition. Third, there's a dovetailed or complementary pattern of deceit and concealment of the relationship and the money. Fourth, the speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense of this motion to disqualify, especially the hearing. On the financial piece, the court asked for a limiting principle. and asked about materiality. The limiting principle is whatever impairs the independent professional judgment of the lawyer. That is applied routinely. We have a county code section that flatly prohibits gifts from contractors, period. We have, by analogy, the federal bribery statute, which has a threshold of $5,000, 18 U.S.C. 666. The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory based on State v. Thomas, 311 Georgia 407, particularly footnote 19. As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began. Each one of them afflicted or conflicted under county and common law. The second conflict is her political ambition, for which he was previously chastised by Judge McBurney, and that's also present in this book. The inside flap of this book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages, and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book. I introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. The stack of law from the state constitution down to the county ordinances imposes a regime on the DA under which she has 3 obligations. She has to go to the county commission to get approval to pay him like she did. She cannot accept gifts from a prohibited source. She has to disclose the gifts that she received. She evaded all of those requirements. Section 2-69 of the county code prohibits gifts from prohibited sources, which he was. There is no boyfriend exception. The disclosure forms, the evidence is sufficient for you to find that her disclosure form for 2022 is false, and that it is a false writing. That's an actual conflict of interest between her duty, legal duty of disclosure, her legal duty of candor as a prosecutor, and her private and personal interests in concealing the relationship, concealing the gifts, and keeping the gravy train rolling for as long as possible. His part in the pattern of concealment is a story you see in many divorce cases. The husband is hiding things from his wife. How much money he's making, the other woman, and what he's spending on the other woman. And he got on that stand, lied in his interrogatories, and then he got on the stand and he lied about lying in the interrogatories. And the lawyers for the DA's office, they just sat there and let him do it. They did nothing to correct obviously perjured testimony. In and of itself, that warrants disqualification of every one of them. The reason they lied and covered it up was to avoid the trouble they're in right now. That served their personal interests to the detriment of their public duties as prosecutors. The speech at the church, I want to focus on why she did that. Mr. Gillen talked about that. She did it to deflect attention from her own misconduct and that of Mr. Wade. She violated her public duty as a prosecutor to serve her personal interests and the personal interests of her boyfriend. That is a disqualifying conflict between her personal interests and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce. I filed a certified copy of that as Exhibit 37. She sought a protective order under the Apex Doctrine on the grounds that she's the DA. The whole filing is expressly predicated on her status as DA. In fact, she never lets you forget it. She says it 27 times in 12 pages. In that filing, speaking as DA, she said, the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis, and in doing so is obstructing and interfering with an ongoing criminal investigation. In the prayer for relief on page 11, she asked for 6 months to, quote, complete a review of the filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends. There's no sugarcoating it. That's a clear violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case. She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce. She violated her public duties not to make that kind of a threat in order to serve her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing. There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony. Most of those objections were made by the state, but the privilege being asserted does not belong to the state. It belongs to Mr. Wade. That shows that the DA's office is serving the personal interests of the DA and Mr. Wade in carrying out further concealment and cover-up of their relationship, and not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of the wrongful pattern of concealment and cover-up that they've engaged in since the beginning. But now they've enlisted the entire office in the enterprise. In the written response to the motion to disqualify, they said this, and I quote, "To be absolutely clear, there is no evidence that DA Willis derived any financial benefit from Mr. Wade." That's on page 15. Flat out false. 10 lawyers in this case put their name on that, starting with the DA. So throw another log on the bonfire of conflicts of interest. The problem here is the DA cannot distinguish between her personal interests and ambitions on the one hand and her public duties as a prosecutor on the other, and apparently neither can anyone else in their office. Of the 6 conflicts I've identified, only one is subject to a conflict in the evidence. This is a case study in what happens when you operate under a conflict of interest. It's put an irreparable stain on the case. Think of the message that would be sent if they were not disqualified. If this is tolerated, we'll get more of it. This office is a global laughingstock because of their conduct. They should be disqualified and the case should be dismissed.